everyone. Am I audible by the court?
Yes.
Right, thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hi everyone. I am Alihani, the Mooting Club president as well as the judge for today's hearing. Thank you for watching our Mooting Showcase live stream. Before we begin, it would be right for me to explain the objective and agenda of today's event. For today, we aim to expose the righteous way of how mooting is conducted to the law student of Foundation in Law in UiTM Dengkil, especially Part 1 students, as well as, of course, the Part 2 students. For today's court appeal, every counsel will be given 7 minutes to submit and 5 minutes for rebuttals. On behalf of the High Committee Mooting Club, we hope that this mooting showcase will shed light and help students in understanding the protocol in moot court to be applied in our law school, as well as the mooting assignment for the Part 1 students. Please don't forget to submit the attendance link that will be given anytime before the event ends. Please stay tuned till the end. I think that is all from me. I pass the floor to the Mooting Club Vice President. Thank you.
Am I audible by the court? Good evening, councils and members of the floor. Before we commence with the proceedings, on behalf of the judiciary panel, I will explain the flow of the trial. The court will begin by inviting the senior counsel representing the appellant. After the opening speech and submissions by the senior counsel, it will be followed by the junior counsel for the appellants. Then we will proceed with the same procedures for the respondent side. After all the submissions by the counsels, the court will move for 5 minutes recess. Following the recess, we will have a rebuttal session. And finally, another 5 minutes recess before the judgment for the case is delivered. By then, the attendance link will be provided. If there are no concerns to be raised by the counsels, the appeal will now commence. The court invites the senior counsel for appellant side to introduce the parties, the counsels, and the case.
Yes. Am I audible by the court?
Yes, counsel.
Thank you, my lord. May it please this honorable court, I am Faris Zainadizal bin Zainulizal as the senior counsels for the appellant. The co-counsels that are joining me today are Mr. Muhammad Fadli Muhammad Fauzi and Ms. Farah Camelia Harris. My learned friend, Mr. Sufyan, Ms. Dina, and Ms. Nina will represent the respondents in today's case. If it pleases the Lordship, I shall begin summarizing the facts of the case.
Please, counsel.
Today's appellant, Ms. Ariana, is an adventure club advisor in UiTM Dengkil. She organized a team building program at Sungai Congkak in Hulu Langat. Prior to the trip, Ms. Ariana warned all students that no one should be allowed to go near the river to avoid any misfortune. She also insisted that she will not be held accountable and responsible if anyone disregards her warning. In the middle of the program, Ms. Ariana has something urgent to settle and needs to go back early. She asked all students to wait for the bus to pick them up. However, while waiting for the bus, the respondent disregarded the warning and went to play near the river and swam in it. Unfortunately, she slipped into it and almost drowned underwater. As a result of the event, she suffered a mild brain injury. If my lord and my lady have no further question regarding the facts of the case, I shall proceed with my submission.
Counsel, you may proceed with the submissions.
Thank you, my lord. My lord and my lady, my first submission is whether the respondent should be held liable towards the negligence that caused her own injuries. And the grounds of my submission are that the appellant has successfully applied reasonable care to ensure the safety of her student, and the accident is caused by the respondent behaved unreasonably and failed to take reasonable care of herself. To further explain the first ground of my submission, the appellant has successfully applied reasonable care to ensure the safety of her student. This can be referred to in the case of Chan Soon Lee and Chun Wung Pin. In this case, the defendant of the case are the principal and 2 teachers at the school. They had gone with some students of the school for a picnic by the sea. Before swimming in the sea, the students are prevented from going into deep water to avoid any misfortune. While the students were playing a ball game in the shallow water, Some of them apparently moved into a deeper part of the sea and found themselves in difficult situation. The teachers and some boy came to their assistance, but it was found that one of the students was missing. Later, she was found, but they failed to revive her, and unfortunately, she died. In the judgment of the case, the judge found that the defendant owed no duty of care, and even if they owe duty of care, they had done all they possibly could to ensure the safety of the students. And to apply into this case, Miss Ariana have warned and prevent the student from going to the river to avoid any tragedy and misfortune. The action of Miss Ariana are aligned with the defendant in the cases stated. She also insisted that she will not be held accountable and responsible if anyone disregards her warning. Thus, we humbly submit to this honorable court that even though the court found that the appellant owes a duty of care, she has done all she probably could to ensure the safety of her student by preventing them to go to the river and give full supervision towards her student during her presence there, as there is no accident or misfortune occurs when Miss Ariana was there. Before I proceed to the second ground of my submission, do my lord and my lady have further question?
Yes, counsel. First, what is the standard of reasonable care you claim that has been fulfilled by the appellant? And number two, are you saying that the appellant has fulfilled her duty after warning the students not to go near the river?
First, what are the standard of, thank you, my lady, for the question. First, what are the standards of reasonable care that have been applied by the appellant? We see that the appellant is the teacher, and as the capacity of the teacher that need to monitor and supervise more than that need to supervise a lot of students, what she probably could do is that she need to supervise, that she need to instruct them not and prevent them not to go near the river, and that is the best that she could do, as she was the only one. She was the only lecturer at the event. So I do think that what Miss Ariana have done is all she probably could done. And with that being said, I do think that Miss Ariana have successfully applied reasonable care, and the accident occurs because of the respondent disregarded the warning of Miss Ariana and went to go near the river. Did that answer the question?
Yes, I'd like to ask, should the appellant's action of going back early in the middle of the program due to an emergency be set aside?
I would say that it should not be set aside. However, the appellant, which is Miss Ariana, have stated earlier and prevented the student from going to the river earlier. And as a student of, as a foundation student who is 18 years old and can really understand the instruction of Miss Ariana, can understand and understand the instruction of Miss Ariana, I think that the respondent should not go to the river and should prevent herself from being unreasonable behavior. Did that answer your question?
Yes, counsel, you may.
For the second ground of my submission, we agree to submit to this honorable court that the negligence occurs due to the respondent behave unreasonably and fail to take care of herself, which in return causes contributory negligence. To further explain this ground, if I may refer to the case of Jones and Liveout Quarries, where in this case, the defendant, which is an employer who owns the duty of care towards their employee, they have warned their employees not to ride on the back of the excavator to avoid any misfortune or damage. However, the plaintiff disregard this rule and caused his own injury. The court finds that the negligence is not fully accountable towards the defendant, but the injury is partly contributed by the plaintiff as it is a consequence of his own unreasonable behavior. And if we look at today's case, the respondent, which is Zara disregarded and dismissed the instruction of Miss Ariana, which is the appellant. The appellant who owns the duty of care towards the respondent, which is aligned with the defendant in the case of Jones and Liveout Quarries, have clearly stated that no one should go near the river and she will not held responsible if any misfortune or tragedy occurs. The respondent, however, went to the river with her own free will, and because of this unreasonable behavior, thus the accident and the injury occurs. Hence, we humbly submit to this honorable court that by putting the appellant into full responsibility and accountability of the incident is indeed wrong, because by the virtue of the case, the respondent should also be held accountable too, as for his unreasonable behavior have caused the accident and misfortune to occur. Before I conclude my submission, do the lordships have any further questions?
Counsel.
If my lord and my lady have no further question, it can be concluded that in my submission, I have submitted that the respondent should be held liable towards the negligence that caused her own injury on the grounds that appellant has successfully applied reasonable care to ensure the safety of her student, and the accident is caused by the respondent behave unreasonably and failed to take reasonable care of herself. Hence, that concludes my submission. Thank you.
Thank you, counsel. The court will now invite the next counsel to begin with the submissions.
My lord and my lady, I am Miss Farah Camilla Harris and I'm the first co-counsel for the appellant. The second submission I have to make is whether the appellant, Miss Ariana, has breached her duty of care towards the respondent, Zara. Your Honor, the ground of my submission is stated as the leave of the appellant did not breach her duty of care towards the respondent, and the appellant's duty of care is through prevention, which she has fulfilled and did not breach it. If it pleases this honorable court, I will now begin with my submission.
You may begin.
My lord and my lady, we know that breach of duty of care happens when the party does something that is below the minimum standard of care, which can be determined through the reasonable man test. This test is used to determine whether the appellant's conduct is below the standard of care which is expected of a reasonable man. This can be further elaborated in the case of Government of Malaysia and others, and Jumat bin Mahmud and another, whereby the defendant pricked the plaintiff's thigh with a pin. Then the plaintiff turned around and his eye came into contact with the sharp end of a pencil which the defendant was holding. Subsequently, the eye was badly injured and had to be removed. The federal court held that the teacher did not carelessly expose the plaintiff to the injury because the injury was unforeseeable because it was caused by the sharp end of a pencil. All pupils use pencils in the classroom. Hence, it is not a dangerous item to begin with. No constant supervision would have prevented the injury. Therefore, there was no negligence by the teacher. In relation with our current case, the reasonable man test in the case has proved that the appellant did not breach her duty of care. The appellant left the program due to something desperately urgent that needs to be settled immediately, which is very reasonable because it is an emergency after all, which is more important than a school program. Any reasonable man would do that. And plus, the appellant even advised the students to wait for the bus to leave Sungai Chongkak, meaning that the program has already ended. So by right, it is permissible for the appellant to leave. And it is also important to note that the appellant has entirely completed her duty of care in all her powers by managing the whole program properly. She has taken reasonable steps to prevent any misfortune by reminding the students about the rules before and after the program, because it is in her nature to advise and remind the rules. Additionally, the appellant has prepared the transportation process, managed the activities, and taken care of the reservation. And on top of that, even before she left, she advised the students to solely wait for the bus, meaning that they must be in good behavior. And overall, the appellant has done her best to make sure the program went well to prevent any problem. Breach of duty of care only occurs if the appellant does not bother to manage the program properly and fails to prevent the students from harm. And therefore, with all of the work, preparation, and prevention that she has put into the program, it is not foreseeable that the respondent would still suffer from such damage. And before I proceed with my submission, does my honor have any question?
Yes, Counsel. Counsel, you have mentioned the unforeseeability aspect of Jumat's case. How does this align with the facts of the current case? Are you implying that the respondent's actions are unforeseeable?
Thank you, my lord, for the question. Now, the relation with our case and the Jumat's case is all about expectation. In the Jumat's case, it is not expected by anyone that a small pencil can cause such damage to the point where the eye had to be removed. Same goes to our situation. The appellant, Miss Ariana, had warned the students beforehand about the danger of the river. And before she even left the students, she even advised the students to solely wait for the bus, not to go stroll around in the forest, not to explore. No. The appellant had explicitly told the students to solely wait for the bus. And with all of these precaution that she has given to the students, it is not foreseeable, not expected for the respondent to slip and nearly drown in the river. Does
Thank you,
that answer?
Counsel. You may
Right.
proceed with the submissions.
Thank you, my lord. I will now proceed. According to the Richards and State of Victoria case, the plaintiff suffered brain damage as a result of a fistfight which occurred in a classroom and in the presence of a teacher. The damage which caused serious injuries to the plaintiff started from an argument, a scuffle, and then a fight. The court held that the duty of care owed by the teacher only required reasonable measures to prevent physical injury to the pupils. The duty of care was never about protecting against injury, but it was about taking reasonable care to prevent it. In relation to our current case, the whole duty of care by the appellant was substantially to prevent the students from any harm, and she has successfully done so by advising them plenty of times. One was when she warned the students not to go near the river before the program. Second, she was there during the program, and logically speaking, she must have explained and reminded all the rules again to the students because she is the advisor and the supervisor after all. That is what advisors are for. They are there to advise. And lastly, even before she left, she already advised the students to solely wait for the bus to pick them up patiently. It is crystal clear that the appellant has successfully fulfilled her duty of care through prevention, because breach only occurs if she fails to prevent, not when she fails to protect. Therefore, the duty of care by the appellant is substantially about prevention and not about protection after all. In conclusion, the appellant Ms. Ariana did not breach her duty of care because the damage was not foreseeable and she successfully fulfilled her whole duty of care through prevention. And therefore, I implore this honorable court to allow this appeal as negligence never occurred. Clearly, the respondent herself had neglected all the precautions given to her. That is all for my submission. Thank you.
Thank you, Counsel. The court will now invite the next counsel to begin with their submissions.
If it pleases the court, I am Mr. Muhammad Fadli Muhammad Fauzi, appearing as the second co-counsel for the appellate. My lord and my lady, the third and last submission I have to make is whether the damage suffered by the respondent is solely caused by the action of the appellant who left the students due to the emergency matter even after warning them to not go near the river to avoid any accident from happening. Your Honor, the ground for my submission is we believe that the appellant does not held accountable for the damage suffered by the respondent because the appellant has fulfilled her responsibility by giving the students warning and stated that she will not be responsible for any harm due to the disobedience of the students to the instruction given. My lord and my lady, if it pleases your lordship, I will begin with my submission.
Yes,
In
please.
order to accuse and put the blame on the appellant for the damage suffered by the respondent, there are two elements that must be considered by the court, which are through the but-for test and possession in law. Today, I will present the argument using these two elements in proving that the appellant is not responsible for the damage that happened. Firstly, for the Bedford case, I will be referring to the case of Barnett and Chelsea and Kensington Hospital Management Committee, where the plaintiff's husband went to the defendant's hospital when he started vomiting after drinking some tea. The nurse on duty called the doctor who instructed the nurse to tell the plaintiff to go home and call his own doctor. Later that afternoon, the plaintiff's husband died of arsenic poisoning, and the plaintiff sued the hospital for negligence for its failure to treat her husband. The court held that the doctor had breached his duty of care to the plaintiff's husband. However, the breach of duty he made did not cause the death of the plaintiff's husband because the plaintiff's husband could not be saved even if the doctor had treated him with proper care. To relate this case to our case, the absence of Miss Ariana at the place of incident does not result in the damage suffered by the respondent because she has given the students warning and her absence was due to an unavoidable emergency which should not be considered as breach of duty. Moreover, let's say that Miss Ariana was present at that time. The respondent will still go to the river when Miss Ariana is not near. It is important to bear in mind that Miss Ariana is the only supervisor of the program, which probably involved a bus full of around 50 students. Thus, it is not possible for a single advisor at a spacious open public forest that is packed with trees and to supervise all 50 students at the same time. Therefore, the respondent will still suffer from the damage even if the appellant was present. Before I proceed with my submission, does my lord or my lady have any question?
Yes, counsel. Are you implying that verbal action of prevention is an effective form of prevention for the students? Or do you imply that the appellant should prevent the students from going to the river in other effective ways?
Thank you, my lady, for bringing the matter up. To answer that question, a verbal action of prevention is effective and adequate prevention taken by the appellant to make sure that all students are safe. It is because we need to it is because we need to note here that the appellant was dealing with the student of UiTM Hill, which clearly has passed the age of majority. Therefore, it is in their capacity to understand and obey the warning and instruction given. I hope that answers your question, my lady.
Also, why do you presume that the respondent will still go to the river when the appellant is not near? What is the basis of your presumptions?
Thank you, my lady, for the question. Let's look at it from the perspective of psychological explanation. I am pretty sure that the court is familiar with the term of conformity before, where people tend to confirm other people's behavior. In this case, he would conform majority people's behavior, which is by not going to the river. However, she resists the pressure to conform the rule due to several factors, which are the desire of personal control. So the respondent might think that she is mature enough and big enough to act on her own, which makes her to follow her desire and go against the appellant instruction. Moreover, the second factor is the desire to be unique, which can be applied onto the respondent's action because she followed the minority people into the river. Might makes her seem unique and different from others. Thus, she will snatch every opportunity to do what she desires instead of what she was told to do. I hope that clear up your doubt, my lady.
Also, you may proceed.
I will now proceed. If the court has doubt with my argument under that forecast, the next step in proving the innocence of the appellant will be used, which is by putting the appellant through the causation of law, where the appellant will only be liable for negligence if it is reasonably foreseeable that her conduct will cause some degree of damage to the plaintiff. Referring to the case of Chan Soon Lee and Chong Boon Pin, which the facts of the case have been stated by the senior counsel. Does the court need a recap of the facts?
No, thank you.
I'm sorry, my lady.
No, counsel, you may proceed.
Relate that case to our case, Miss Ariana had done all she could, which was by warning the students not to go into the river and instructing them to wait for the bus to pick them up. As the grown-up students of UITM Hill, they should have done the instruction because it is in their capacity to think and consider the actions that could result in harm and to follow the instructions given by the appellant, which was clearly given for their own safety. Nevertheless, the damage suffered by the respondent is not foreseeable because the appellant has done her best in preparing and managing the program. The appellant has warned about the river before the trip and before she left. She even advised the students to wait for the bus patiently, meaning that the students must be in good behavior until the bus arrives. Therefore, with all of the appellant's preparation and prevention for the program, it is not foreseeable for the respondent to still suffer from the damage. Hence, the appellant is not liable for negligence. Before I continue with the conclusion of my submission, does my lord or my lady have any question?
No, counsel, thank you.
In conclusion, the appellant is not in the position to be blamed for the damage suffered by the respondent on the ground of negligence because she has done adequate precautions in ensuring that no misfortune occurred, and it is Zara who should be responsible for her own injury due to the contributory negligence she committed. My lord and my lady, it is for this reason and also those given by my senior counsel and the first co-counsel that I would urge you to allow this appeal. If your lordship has no further questions, that concludes the case for the appellant.
Thank you, counsel. I believe that's all the submissions from the appellant side. Now we will move to the respondent side. Senior counsel, you may begin with your speech.
May it please the court, as been mentioned by the senior counsel of the appellant earlier, my name is Muhammad Sufian Hakim bin Misrum, and I am the senior counsel for the respondent. My lane junior counsel, namely Ms. Ain Adlina and Ms. Irina Sofina, will also represent on behalf of our client, Ms. Zara. With the permission of the court, I would like to begin my submission.
Counsel, you may begin.
Thank you, my lord. My lord, we will have three submissions that are to be made upon this honorable court. The first one is that the appellant is liable for having a legal duty of care. Secondly, is that the appellant had indeed breached her duty of care, and following to that, the appellant omission had caused the respondent to suffer damage. I will begin my submission on the issue of whether the appellant can be held liable under the virtue of element of negligence for having a legal duty of care toward my client, Ms. Zara. Your Honor, the ground of submission for this case is that we believe that the action of the appellant leaving her student to solve some matter does not indicate that the appellant was excluded from having a legal duty of care towards the participant, specifically Ms. Zara. Therefore, marking her as completing one of the necessary criteria of negligence, which is having a legal duty of care. My lord, duty of care is recognized as one of the fundamental criteria in the Tortures Act of Negligence. This essential element can be defined as the responsibility of an individual to not harm others through his or her carelessness. In order to determine whether duty of care can be established or not, a mechanism identified as the neighborhood principle is implemented. As for the neighborhood principle, it is stipulated in the case of Donoghue and Stevenson. Lord Atkin, who was the judge in this case, has explained that a person must take reasonable care to avoid any acts or omission which can be reasonably foreseen to cause any injury towards your neighbor. The said neighbor is the person who is closely and directly affected by the action of the torture. And this careless act is ought reasonably to have them in contemplation as being affected. So, as referring to the neighborhood principle which I have stated earlier, it is clear here that the appellant has established a legal duty of care as her action as closely and significantly affected the well-being of my respondent. This can be seen as my client, who was a participant in the program, has suffered great injuries of mild brain damage, and that has ultimately put her in a coma state for days due to the action of the appellant. It is to note that the appellant, who is Ms. Ariana, is the official Adventure Club advisor, which is responsible to take care of the participants in the program. It goes without a doubt that the club advisor is under a duty to exercise supervision over his pupils, whether it is inside the university compound or in this case at Sungai Chongka, where the program is being held. This means that she has to provide a proper guidance to the participant, impose clear rules and restrictions, and most important of all, she must be present in the material time to make sure that everything is in a proper order to prevent any unwanted incident from happening. However, that is not exactly what happened in this matter. But before I continue any further, does my lord have any question to be asked?
Yes, Counsel. In regards to the duty of care, from the facts of the case, the appellant had explicitly stated that to the students that she will not be held liable or accountable for her actions if anyone disregards the rules. Do you think that should exclude the appellant from the legal duty of care?
Thank you, Your Honor, for asking that question. As for my stance, it is no. I firmly believe that the appellant mere reminder prior to the program is not sufficient to exclude her from having a legal duty of care. As I explained earlier, the appellant already established a legal duty of care towards the participant as she is the advisor of the Adventure Club. However, she cannot claim that she will not be held responsible if someone disobeys the instruction, as it is a responsibility as the person in charge to remind the student from time to time to not play near the river. She only remind the student prior to the trip. Surely she can remind the student a few more times, especially after they arrive at Sungai Chongka. We have to keep in mind that these students are excited to enjoy the program, and it is reasonable for them to forget about the instruction. Therefore, the appellant mere reminder does not exclude her from having a legal duty of care, as the reminder itself is not sufficient for the student to remember. Does that answer your question, my lord?
Yes, Counsel. Thank you. You may proceed with the submission.
Thank you, my lord. As for my second submission, it is stipulated in the case of Muhammad Raihan bin Ibrahim and another, and Government of Malaysia and other. In this case, the first appellant sustained injuries when he was accidentally struck on the head by a chanko wielded by a fellow pupil in practical gardening class. The appellant sued for damages, claiming that the respondent failed to provide proper supervision of the pupils participating in the gardening class, and also she had failed to instruct the people who caused the injury on the proper use of chanko. Although it is dismissed on the High Court, the appeal is given on the ground that the respondent were negligent for failing to take all reasonable and proper steps. And secondly, the teacher was appreciating that the boys were handling dangerous instruments and had not given sufficient warning to them. Chief Judge Raja Azlan Shah held that, having regard to what I have discussed earlier, the respondent were therefore negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining injury, and that their teacher did not check the condition of the garden tool, nor provided a safe system for these kids in holding the gardening class. Ms. Hao Kan Yong, which is the appellant in this case, was sitting under a tree about 4 yards away from the appellant, and that was then not even looking at the people. Even worse, the teacher was appreciating that the boys were handling dangerous instruments and has not given sufficient warning as to their use, nor she had taken steps to avoid any injuries from being inflicted. Then, the people also were left on their own to take tools from the storeroom, and neither Miss Hao Kan Yong nor any other teacher did distribute them. Your Honor, therefore, referring to the case that I have mentioned just now, it is clear here that the appellant were negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining a dangerous injury. The two persons in charge for both situations had left their respective posts to attend another matter. The appellant simply told the participant that she had to rush somewhere to take care of emergency matter, and she left the student on their own while waiting for the bus to come. Shouldn't she at least appointed a new qualified person to supervise the student? With the lack of a person in charge, a quick response cannot be initiated to save the client from sustaining an injury. A few minutes earlier may lessen the degree of the injury suffered by my client. Your Honor, although it is not denied that the appellant has given a warning not to play near the river, and also she had given instruction for the student to wait patiently for the bus. However, it can be said that the degree of the seriousness of the warning is not to be taken seriously. Similar to the case that I stated earlier, the warning is not sufficient because the appellant can be argued of only wanting to save herself from the problem by further saying that she will not be held accountable if anyone disobey the reminder that she had given. So I want to state it that it is the appellant responsibility to at least repeat the warning several times before and during the program if she already knows the great danger that the river might bring. Thus, the appellant claim cannot be held accountable due to an already given prior warning does not amount that her duty of care is excluded from providing supervision to the participant. My Lord, I noticed that my time is almost expired. I want to state it that indeed the appellant had a legal duty of care towards the participant, and that her reminder or instruction prior to the program that she will not be held accountable is invalid. Therefore, it is for this reason and those that will be given by my junior counsel that I would like to implore the court to allow this case. If your lordship has no further question, that concludes my submission regarding this matter. Thank you.
Thank you, Senior Counsel. The court now invites the next counsel to begin with their submission.
If it pleases the court, as has already been stated, my name is Idina Sofina and I appear as junior counsel for the respondent. With the Honourable Court's permission, I would like to reserve 7 minutes to deliver my submission. Your Honour, I only have one submission to make, which is whether there was a breach of duty of care made by the appellant towards the respondent. The ground for my submission is that we believe that the appellant is liable to negligence when she went back early in the middle of the program for urgent personal matters, leaving all the students unsupervised in Hulu Langat, 43.3 kilometers away from UiTM Dengkil. Based on the principle of law, her action has satisfied one of the key elements of negligence, which is the breaching of duty of care. If it pleases the Honourable Court, I'll begin with my submission.
Yes, counsel.
Your Honour, breach occurs when a person does something that is perceived to be below the minimum standard of care required of him. The reasonable man test is to determine whether a person's conduct fell below the standard of care which is expected of a reasonable man, and thus whether there has been a breach of duty of care. Who is a reasonable man? A reasonable man is defined as an ordinary person not expected to have any particular skills such as the skills possessed by a lawyer or a doctor unless he is actually one. Under the circumstances where there have been suspicions of breach of duty of care, it is necessary to ask what a reasonable man would have foreseen and done. The conduct of a reasonable man is subjected to the concept of risk based on the principle of law of the reasonable man test. In considering whether the appellants were in breach of duty of care, it is necessary to consider whether the risk of injury to the respondent was reasonably foreseeable. Assuming that it was foreseeable, the next question is whether the appellant had taken reasonable steps to protect the respondent against those risks. To further demonstrate the principle of law that proves there was a breach of duty of care made by the appellant towards the respondent, allow me to cite the case of Muhammad Rahan Ibrahim against the government of Malaysia. Before that, does Your Honour would like a recap of the matter of facts of the case?
Yes, please.
Thank you, Your Honour. In this case, the appellant was a student that took part in the practical agriculture class. The pupils were told to pick up agricultural tools such as spades, changkos, and baskets from the storeroom. The appellant and his fellow pupil Raja Aminuddin then worked closely together to raise the level of the vegetable bed. Since they were close in distance to each other, the appellant was accidentally struck on the head by Raja Aminuddin's changko. The teacher of the class was sitting 4 yards away from the appellant and was not looking at the pupils at the time. She only turned to the direction of the appellant when she heard someone calling out for her, and only then she saw the appellant's head bleeding. Turns out the appellant had suffered a severe injury on his head. The appellant then sued the respondents on the ground that they had failed to provide supervision of the pupils who participated in the gardening class. The federal court held that the respondents were negligent for failing to take reasonable steps to prevent the appellant from sustaining the injury, and that the teacher did not provide a safe system of holding the gardening class. The teacher claimed that she simply told the pupils in a general way not to be near one another. Your Honor, allow me to make comparisons and apply the same legal principle of the case of Muhammad Rahim Ibrahim against the government of Malaysia. Just like the respondent in the said case, the appellant, Ms. Erna, also did in fact foresee the risky situation. This can be evidently seen when the appellant warned the students to not go near the river in order to avoid any misfortune. This shows that the appellant is totally aware of the risky situation, and she knows that there's a chance misfortune could happen if she did not warn the students. Next, whether the appellant has taken reasonable steps to prevent the misfortune. The appellant did give them a warning to not go near the river, but merely warning them is not enough. We can see here the precaution the appellant took is inadequate. The extent of the reasonable precaution she took should be too rough and be able to guarantee any misfortunes from happening. Not to mention, the team building program that she organized herself is somewhere far from the ITM Dengkil, which is Hulu Langat in Negeri Sembilan, an environment in which the students wouldn't be familiar with if they were to ask help from the surroundings. In the judgment of the said case, Saleh Abbas, the federal judge contended that as regards warnings, the teacher had said she warned the pupils to be careful and not to fool around. But is the giving of such general warning as this sufficient when the pupils being of a very young age and were enjoying each other's presence? Secondly, the judge also contended that the boys were simply left to their own devices with general instructions to complete the work as best as they could. Under the circumstances, we are of the view that a mere warning to be careful does not amount to proper supervision, especially when it is established that the boys were of young age and in jovial moods. Before I proceed with my submission, does the Lordship have any questions?
Yes, Counsel. The circumstances where the appellant had to return due to an emergency, what other reasonable measures could the appellant have taken to satisfy the standard of care?
Thank you, Your Honor, for having raised that point. My co-counsels and I believe that some of the reasonable steps that the appellant could have done is by enforcing the High Committee of the Adventure Club to be on duty, or ask the High Committee members to remind their fellow club members to not go near the river and observe the students at all times. We believe that the appellant could also have put on warning tapes around the river prior to the trip just to heighten the students' awareness. Does that answer your question, Your Honor?
You may proceed.
Your Honor, I'm aware that my client who is studying in UiTM Dengkil is of 18 years old and therefore has reached the age of majority in Malaysia, which indicates that she is already an adult. However, it has been less than a year since they became an adult. Simply relying on the age of majority and the maturity of the students to have good faith that they would abide by the appellant's warning when they are unsupervised is not enough and merely a fragile faith. Rationally speaking, if relying on the claim that my client is an adult and hence should know better than going to the river, would the appellant so much as to want other adults not to go near the river? Hypothetically speaking, she would not, because matured adults would not go and play near the dangerous river. However, in this case, she warned the students because she believed that these young adults are not fully developed yet in their emotional intelligence as compared to other matured adults. Let's have another look at what the federal judge said. He claimed that a mere warning to be careful does not amount to proper supervision, especially when it is established that the boys are in jovial moods. Relating his claim to my client's case, the appellant's warning is inadequate and does not amount to proper supervision. Not only the appellant merely gave the students only a warning, but she also only warned them once, which was prior to the trip. In addition to that, just like the boys in the cited case who were in jovial moods, my client too was feeling the same, given the fact that she was happily playing near the river with her friends before she accidentally slipped into the river. Distracted by her excitement of playing with her friends made her forget the exposure to dangerous situations. Furthermore, the purpose of the program that the appellant herself organizes is to strengthen the bonding between the members of the club. Needless to say, the students need constant reminders of the dangers and full-time supervision to calm down their enthusiasm. Hence, the lack of supervision made by the appellant clearly proves that there was indeed a breach of duty of care made by the appellant towards my client, Ms. Zara. Before I conclude my submission, does Your Honor have any questions?
Yes, counsel. In your submission, you stated that the respondent had barely reached the age of majority. Are you implying that the actions of the respondents are reasonable and to be expected of a reasonable 18 years old?
Thank you, Your Honor, for the question. We believe that the actions of the respondent are reasonable because despite my client having reached the age of majority, as has been mentioned along with my cited case, my client is still young is excited to be left alone with their friends unsupervised. Therefore, her age should not matter in this case. Does that answer your question, Your Honor?
Yes, counsel.
If Your Honor has no further question, I'll proceed with my conclusion. To conclude, I implore the Honourable Court to dismiss the appeal on the ground that the appellant is liable to negligence, as she has satisfied one of the key elements of negligence, which is the breaching of duty of care. With that, thank you.
Thank you, counsel. We will now move to the final counsel for the respondent side.
Am I audible to the court?
Yes.
Thank you, my lord. May I please the honorable court?
You may proceed with the submissions.
As previously stated, I am Ain Adina, acting as the junior counsel on behalf of the respondent, Ms. Zara. With the honorable court's permission, I would like to reserve 7 minutes to deliver my submission.
Yes, counsel, you may proceed.
I have one submission to make on behalf of my client. That is, the appellant, Ms. Ariana's breach of duty of care had resulted in the damage suffered by the respondent. My lord and lady, the ground for my submission is we believe that the damage suffered by my client was indeed a direct consequence of Ms. Ariana's actions, as it was foreseeable and can be anticipated to occur. First of all, damage can be categorized as personal physical injury that has occurred towards the victim due to the other party's act of negligence. It is the final element of negligence that must be proven in order for the appellant, Ms. Ariana, to be considered negligent towards my client. In this case, the respondent, Zara, has suffered damage in the form of physical injury when she temporarily drowned in the dangerous river of Sungai Chongka and was left with brain damage and body unresponsiveness. My lord, allow me to prove the direct consequence of my client's damage due to the actions committed by the appellant through the first established test, which is the but-for test. The question raised through this test is, but for the defendant's breach of duty, would the plaintiff have suffered the damage anyway? My learned friend from the appellant side submits that it is impossible for a single advisor at a spacious public forest to supervise that many students all at once. My lord, allow me to recapitulate the chronicle of events that have unfolded during my client's previous stay with the rest of the students of UITM Dinkil's Adventure Club at Sungai Chongka. Despite the fact that the program was held near a dangerous river, not a single accident occurred among the students, while Ms. Ariana was present, as she was the sole authority representing UITM Dinkil. Zara, my client, was likewise in great shape and most significantly, safe. This is because the students clearly respected and feared defying a lecturer's orders for fears of earning demerits. The mishap involving my client happened precisely when Ms. Ariana left the students in the middle of the session to attend her own matters. It proves the size of the location was never a factor in establishing the students' safety, but the presence of an authority. This indicates if Ms. Ariana had not abruptly left the students on their own in the middle of a program with only a brief warning, my client would not have suffered the damage. This is why we from the respondent side believe Ms. Ariana's abrupt departure was a proximate cause of my client's bodily injury. Hence, we believe the but-for test has been completed. Moving on, the causation in law test is the second established test that will be utilized to evaluate if there was a direct sequence of events between the appellant's act and the respondent's damage. In this case, the appellant, Ms. Ariana, will be liable for the damage only if it is fairly predicted that her actions would create some degree of damage to the respondent. My lord, allow me to cite the case of Home Office and Dorset Yacht Company 1970. Before I proceed, would the Honourable Court like a brief summary of the facts of the case?
Yes, please.
Certainly, my lord. In the case of Home Office and Dorset Yacht Company 1970, several young men aged between 15 to 20 years old were working on the Brown Sea Island under the supervision of 3 officers. The issue began when the officers went to bed, leaving all of these young men alone to work unsupervised. The young men then stole a yacht and rammed it into the claimant's personal boat. Later, it was established that the Home Office earned a duty of care because they possessed control over the third party that had caused the damage. The relevant issue in these cases: does the fact that competent and mature adults perform the negligent act break the chain of causation with the officers? In this case, the court established that the result of the damage would not have occurred if the officers were not negligent and had continued to monitor the young men. In his judgment of the case, Lord Reid mentioned that the act of the young men stealing a neighboring boat and damaging another belonging to the respondents could have been anticipated by the officers, as it was foreseeable to happen if they failed to exercise sufficient supervision. To apply to our case, by taking the students of Sungai Chongka, which was established to possess a dangerous river, Miss Ariana, acting as the only lecturer and supervisor of the entire program, was in charge of the safety of all of the students, including my client. Thus, she ought to have been able to foresee that an accident may have occurred if she failed to exercise proper control. My lord, let us take a look at the situation once again. A bunch of newly 18-year-old students left alone, unsupervised, in the middle of a camp with a dangerous river. Despite the students having attained majority age and despite the brief warning, generally, Ms. Ariana, as the lecturer, should have anticipated the likelihood of accidents occurring due to a variety of causes. 1. The buses which she instructed the students to board may have arrived a little sooner than expected, which resulted in a few of the students submerging into boredom and playing in the river. 2nd, witnessing one student in the river would encourage the others, including my client, to participate. This is due as students tend to conform with their peers and follow crowd decisions. Hence, Ms. Ariana, as an established lecturer, should have been well aware that her brief warnings to the students not to play in the river would never be sufficient, as in the end, these students are still young and ignorant, newly 18, fresh out of high school, and freshly imprinted with the legal adult brand in Malaysia. They are still traversing the real world and attempting to determine which neuronal channel of thought to take. Young, daring, and risk-takers. These are the real characteristics of students, which lecturers such as Ms. Ariana should be well aware of. And by virtue of the cited case Home Office and Dorset Yacht Company, the respondent's age did not have much weight in the circumstances. It does not absolve the appellant, Ms. Ariana, of her responsibility and the duty of care she had towards my client. Thus, we strongly believe Ms. Ariana was negligent towards my client, as such accidents to occur were indeed foreseeable. Before I conclude my submission, does the Honourable Court have any questions?
Yes, Counsel. When referring to the incident of the respondent joining their friends in the river, you mentioned that the students tend to conform with their peers and follow crowd decisions. How does that statement justify your submission on the but-for test against the appellant when the incident could have been attributed to disconformity or behavior instead?
I would like to thank my lord for raising the question. My lord, when I mentioned that the students tend to conform with their peers and follow crowd decisions, I was indicating that without the presence of an authority such as Ms. Ariana nearby, it was seen that the students were finally bold enough to collectively defy her orders of not playing in the river. I would like to remind my lord once again that no accident had occurred when Ms. Ariana was present to supervise them. Hence, it is without her presence and her clear breach of duty in the first place that led to the situation in which some of the students conformed and followed crowd decisions by playing in the river, which then resulted in my client suffering the injury. And as seen by the chronicle of events of the case, the accident would not have happened if Miss Ariana did not breach her duty of care in the first place. Therefore, I believe my point stands as it aligns with the principle established in the but-for test. As for the defendant's breach of duty, the students would not have been able to conform with one another to go against the order in the first place. And as the following result, my client would not have suffered the damage. I hope that answers my Lord's question.
Thank you, Counsel. You may proceed with the submissions.
Thank you, my Lord. To conclude, I urge the Honourable Court to dismiss this case as the appellant's breach of duty of care is unequivocally a direct correlation to the damage suffered by my client. Thank you, my Lord, for your time.
Thank you, Junior Counsel. And that concludes the submissions from the respondent. The court will now move to 5 minutes recess for counsels to prepare their points for rebuttals. The court will now resume with the proceedings of the case. The court would like to invite the appellant side to make their grounds for rebuttals.
Thank you, my lord. My lord and my lady, for the rebuttal, each representative speaker is given up to 5 minutes to rebut. Now, without further ado, I will now begin with my rebuttal. It is indeed that I have three It is indeed that I have 3 points to make. For the first point, I will be touching on the respondent's contributory negligence. The opposing counsel stated that the respondent being around the age of 18 is struggling to form rational decisions. My lord and my lady, this is not about business plans, economics, politics, marriage, parenthood, or rocket science. Yes, they are immature in terms of that. However, this is all about survival instincts. When we are hungry, we eat. And when we are tired, we sleep. People nearing the end of their teenagehood, which is 18, have strongly developed danger instincts to prevent themselves from danger, just like animals would camouflage themselves when they sense their enemies. Therefore, yes, the respondent being 18 is undoubtedly capable of forming rational decisions to not play near the river. On the other hand, the opposing counsel stated that due to Zara being young, she was full of enthusiasm and playfulness, hence why she played in the river while waiting for the bus. My lord and my lady, this is not valid at all. The river was not the one and only source of enjoyment in Sungai Chongka. The respondent could have done other fun things such as chatting with friends, having storytelling sessions, playing card games, chatting, and taking pictures with nature. However, it is undeniable that playing in the river seems innocent, but it must be done with moderation. Clearly, the respondent played in the river for too long without moderation to the point where she slipped and nearly drowned. If she played with moderation, she would not slip because there were other students who played near the river as well. But why didn't they sleep? Why is it only Zara sleeping? Therefore, yes, the respondent was negligent towards herself by not being moderate and by neglecting her rationality. For the second point, I will be touching on the alleged breach of duty of care. The opposing counsel stated that the appellant has failed to provide adequate guidance and gave lax supervision. My lord and my lady, even though the appellant stated that she would not be held liable if anyone breaks the rules, it does not mean that the safety of the students are totally jeopardized. Let me stress that the appellant was the one organizing the program, conducting the activities, handling the revenue costing, and also the transportation process. Therefore, the appellant has done everything in her powers to prevent any misfortune throughout the program. On top of that, she has clearly advised and warned the students about the rules. My lord and my lady, any advisors, teachers, or even parents would advise as it is in their nature. Any authority in control would always announce the rules. She warned about the river before the program, and let's not forget, even before the appellant left, she even advised the students to solely wait for the bus patiently, meaning that the students must be in good behavior until the bus arrives to prevent any misfortune. My lord and my lady, if anything, that is too much prevention for an 18-year-old adult. Clearly, the respondent has neglected the advice and the warning given to her. Let me emphasize again that breach of duty of care only happens if the authority fails to prevent, not when they fail to protect. Therefore, the appellant did not breach her duty of care as she had done her best in preventing harm to the students. And as for my last point, I will be touching on the damage of the respondent. The opposing counsel stated that, according to the but-for test, the respondent would not have suffered from mild brain damage if the appellant was present. My lord and my lady, this is not valid. The respondent would still have suffered from mild brain damage even if the appellant was there. This is because the appellant is the only advisor and supervisor during the program, handling 50+ students. in an open public forest which is very spacious and filled with trees and rivers. My lord and my lady, this is not the same setting as the usual classroom in a building. It is not humanly possible for a single advisor to supervise everyone all at once. For instance, if the appellant was present during the incident and she's busy discussing with the Sungai Chongkat staff, she would still overlook the commotion at the distant river, and Zara would still be saved 5 minutes later as well. Therefore, the respondent would still suffer the damage even if the appellant was present. That is all for my rebuttal. We, the appellant counsels, implore this honorable court to allow this appeal to uphold justice upon the appellant as negligence never occurred. Now, I will give the floor to the representative of the respondent, Ms. Indina Sofina.
Thank you, counsel. Respondent side, you may begin with your rebuttals.
If it pleases the court, my name is Indina Sofina and I would like to reserve 5 minutes for my rebuttal. Your Honor, I would like to bring the attention of the court to the contradictory claim from the appellants. The appellants cite the case of Chan Soon Lee against Chong Voon Pin, in which the judgment held that the appellant owes no duty of care. In the appellant's first submission, they also stated that only the respondent should be held liable towards the negligence that caused her own injuries. This shows that the appellants believe that their client, Ms. Ariana, owes no duty of care. However, the appellants contradict that claim because in their later submission, they claim that there was no breach of duty of care and that she has successfully fulfilled her whole duty of care through prevention. Hence, this proves that their claims in which only my client is liable to negligence and that their client, Ms. Ariana, owes no duty of care is invalid. Next, if it pleases the court, I would like to highlight the appellant's usage of the word prevention. The appellant stated that there was no breach of duty of care made by their client as she has successfully fulfilled her duty of care through prevention. With the court's permission, I would like to derive the definition of the word prevention from the 8th edition of the Oxford Advanced Learner's Dictionary. Prevention is defined as an act of stopping something bad from happening. Your Honor, rationally speaking, merely warning the students to refrain from going near the river is not an act potent enough to prevent the misfortune from happening. Not only in the sense of the term, it is vague and weak. The precaution she took is also inadequate and below the standard of care required of her, as the co-counsels from the respondent side have mentioned numerous times. If the court allows, let me emphasize once again that the extent of the reasonable precaution she took should be to rough and be able to guarantee any misfortunes from happening. Rationally speaking, reliable supervisors that foreseen the risky situation would go beyond instead of just warning them. They would not just leave the students all by themselves in the middle of the program, however urgent the personal matters are. Other than that, the appellant also stated that even if their client, Ms. Ariana, was present at the time this misfortune happened, the respondent will still go to the river when Ms. Ariana is not near. They back up this claim with the justification that it is not possible for a single advisor to supervise all 50 students at the same time. Your Honor, first of all, I would like to remind the court that nothing happened during the time when Ms. Ariana was present on the trip. As has been highlighted by the respondents, it was only when Ms. Ariana left the students in the middle of the program that the accident involving my client occurred. Hence, the appellant's claim that the respondent will still go to the river when Ms. Ariana is not near is inaccurate because even if she's not near, the respondent's knowledge that she is being supervised at the camp would hinder her from going near the river. In addition to that, Your Honor, the appellants claim that it is not possible for a single advisor to supervise all the students at all times. Bear in mind that this trip is a club activity that still needs the approval of director of the Students Affairs Divisions of UiTM Degil. Would director approve of this trip if it is known that it is not possible for Ms. Ariana to supervise the students at all times? Clearly, Ms. Ariana has the capacity to do so, if not for the fact that she has been rather inattentive in carrying out her responsibilities. Last but not least, I would like to bring the court's attention to the submission made by the appellants, in which they claim that the leave of their client did not breach her duty of care towards the respondent. The appellants back up their submission by saying that their client advised the students to wait for the bus to leave Sungai Chongkat, meaning that the program has already ended and by right it is permissible for Ms. Ariana to leave. This is simply fictitious and untrue. If it pleases your lordship, I would like to remind the court that the material facts of my client's case states that Ms. Ariana went back early in the middle of the program and not after the program has already ended. In addition to that, my lord, the appellants also back up their submission by stating that their client has taken reasonable steps to prevent the misfortune by reminding the students about the rules before and during the program, because it is in her nature to advise and remind the rules. The appellants once again refracts from the material facts of the case by generalizing the nature of the advices that would normally repeat the warnings to the students about the danger. As a matter of fact, it is proven that Miss Arna only warns the students once, which was prior to the trip. So much could have happened in that period of time until during the trip, which could ultimately cause the students to forget about the appellant's warning. Hence, my learned friend's failure to stick to the material facts of the case shows that their submission is rather baseless and thus invalid. Your Honour, it is for these reasons and also those given by my senior counsel and co-counsel that I urge you to dismiss the appeal. If it pleases your lordship, that concludes my rebuttals.
Thank you, counsel. So that concludes the rebuttal session. The court will now move to a 3 minutes recess for the judges to discuss the outcome of the case. The court is ready to deliver our judgment. After discussion, the court has found in favor of the appellant, hence the appeal is allowed. We are now going to proceed to give our reasons for doing so. During the trial, there was no doubts in regards to the fact that the appellant is under a legal duty of care towards the respondent, acting as the advisor of the adventure club and organizer of the team building program. However, one of the doubts raised was to what extent was the standard of care to be expected of the appellant. The question following this issue would be, has the appellant satisfied the standard of care? Foreseeability of this incident is one of the elements to be taken into consideration when deciding liability in a negligence case. Based on the submissions and facts of the case, we are in the view that the incident was indeed foreseeable. It is undeniable that the possibility of a person who is the age of majority would act like the respondent had. That is rare for a reasonable person to act in such way. However, there is an actual risk present and the risk did come realized. Therefore, it cannot be brushed aside. Nevertheless, on the issue of standard of care, we would believe that the appellant's side had established that the extent of the standard of care was only to the extent of prevention and not protection, especially taking the age of the students into account. As submitted by both sides, no incident had occurred during the material time when she was present, and no doubt the duty of care does not stop there. The duty of care of a teacher extends until the end of the program, until the student reaches the school safely. However, it's not within the appellant's control that she had to leave. Nonetheless, the court views that she had done to the best of her abilities to prevent any incident from happening by reminding the students to wait by the bus. Therefore, in this case, the principles of contributory negligence had to be applied where the unreasonable behavior of an individual with regard to their own safety results in the foreseeable damage to oneself. On that aspect, we believe that the respondent had failed to act in a manner that is to be expected from a reasonable person, which eventually caused all the injuries that she had suffered herself. For these reasons, we allowed the appeal. I will now pass the floor to Judge Al-Yahani.
Right, thank you, Great. With that, that marks the end of our Mooting showcase. On behalf of the High Committee, I would like to say thank you to everyone that watched the live stream until the end. And as the president of the club, I would like to remind the club members to submit your attendance to gain Cocoa Marks, as well as other viewers to gain Cocoa Marks. We hope that this Mooting showcase helped to expose the righteous way to conduct mooting proceeding. With that, I would like to say thank you so much, everyone.